Counsel, you want to state your appearances, please?
Your Honor, I'm appearing as a deputy arraignment attorney
Okay.
today. I wasn't aware of that something was going on until I looked at the docket. I have the charging document. Neither does
Okay.
Mr. Green, apparently.
Oh, I can let you borrow mine
Okay.
and we can pass the case.
Sure.
All right, I'm back on the record recalling People v. Joe Green. Mr. Green, it's alleged that you are, this is a child support case, and it's alleged that you're in violation of your probation by failing to make regular payments on your child support case in the divorce action, and also by failing to attend substance abuse treatment and not maintaining legitimate employment. Those are the first three counts. Those are technical violations of your probation. If you were found to be in technical violation, one violation is a maximum 15 days in jail, two violations is a maximum 30, three violations is a maximum 45 days in jail. And it's also alleged that you violated state law by using methamphetamines. Actually, with this being not an OWI third case, that would actually be a technical violation as well. So if there's four technical violations, then the court could revoke your probation and sentence you on the underlying case, which is failing to pay child support, which is a 4-year, is that a 4-year? Yes, a 4-year felony. Mr. Green, do you understand the maximum penalties that you could face?
Yes, sir.
Okay, now you do have the right to have a hearing on all these allegations where they would need to be proven by a preponderance of the evidence. You have the right to the assistance of a lawyer. And if you request signed counsel and qualified, then you have counsel at public expense. You can present any evidence you want at that hearing, and you can cross-examine any witnesses that are presented against you. Although the rules of evidence don't apply at probation violation matters except as to privilege. Do you understand the rights that you have, Mr. Green?
Yes, Your Honor.
All right, Mr. Vogler, do you know how he wishes to proceed?
Your Honor, he has informed me that he wants to request court-appointed counsel before proceeding any further.
Okay.
I have the forms with me. Clerk's office would have those. I could have him fill it out before he leaves this morning.
Yes, that'd be fine. And then let's see. I'll enter a plea of not guilty. And Mr. Green, you know, I guess I just want to tell you, in a child support case, you know, it's my sincere hope that we don't end up having to give jail to you. So what I'd like to see happen here, whatever's going on, if these violations are happening, I don't want you to tell me if they are, but if they are, I want to see what you do to correct it. You know, making payments, get yourself a treatment, you know, you know, get a job, communicate with your probation officer. You know, I want to see you succeed on probation. Locking you up doesn't help the child support one bit. Right? But you keeping a job and not using methamphetamine is going to help you get child support. So I want to see those things happen. So we'll enter a not guilty plea. We can schedule it for probation violation hearing February 2nd at 10:10 a.m. And Mr. Vogler, if he does qualify, do you know to whom it will be appointed?
I would be taking the case then.
All right, so Mr. Green, fill out that form, and then do you want him to bring it back in here then?
Yes.
Okay, then bring it back into Mr. Vogler. Okay. And then once you do that, then you're all set to go. Let's call People v. Gauthier. This is file 25-9374FH. Counsel, you want to state your appearances for the record?
Jeremiah Buffalo, work on behalf of the people.
Good morning, Your Honor. Christopher Parks on behalf of Mr. Gauthier, who stands to my right.
We're here for sentencing on a charge of felon possession, 5-year maximum, 0 to 11 guidelines range, and domestic violence, a 93-day misdemeanor. Have you had a chance to review the pre-sentence report and recommendations, Mr. Parks?
I have, Your Honor. I went over them. I took a copy to the jail, went over those with my client. The only issue we had, Your Honor, was to the amount of jail credit. It should be an extra 6 days on there, Your Honor. He should have a credit of a total of 70 as he was arrested before the actual offense date. He spent 5 days in before the date of offense of 10.
Well, hang on a second. The offense occurred on 3/10. How would he get credit for time prior to when he committed the crime?
Your Honor, the offense actually occurred 5 days prior to that. He was incarcerated for those 5 days. He wasn't actually arrested until the actual date of 3/10, which is listed on the report.
Well, it says he was arrested 3/25.
Second time, Your Honor.
Mr. Virgo, you want to help me out?
Your Honor, there was an issue of evidence relative to the firearm that was not discovered until after the initial arrest on regular domestic violence.
So he spent 5 days on that?
I don't have the number in front of me, Your Honor, but I take counsel at his word, and I know that he did spend some time on that before that.
All right, so you have no objection to him getting credit for that time?
It would be appropriate, Your Honor.
All right, so we'll amend it then to
It should be 70, Your Honor.
70 days. Okay. All right, any other additions, corrections, or scoring challenges?
Not from the defense, Your Honor.
Mr. Virgo from the people?
Significant, Your Honor. I don't believe the probation department had the benefit of the knowledge of the post-plea, pre-sentencing contact with the victim in this case that makes the basis for the show cause. The people request that we adjourn the sentencing based on that because there is significant chance that that constitutes post-plea misconduct and would impact the sentencing agreement in this. Further, Your Honor, I do believe that I only have transcripts of those calls right now. I do not have the actual audio yet, but based on those transcripts, I do believe that some new charges would potentially be forthcoming.
Well, there wasn't a sentencing agreement though.
We bandied about a lot, Your Honor. I might be missing on that, but still, I do believe that the content of those.
So you want to address the alleged contempt before we decide on the sentence?
Yes, Your Honor. I do believe that it is directly germane to the sentencing as.
Well, let me explain on that then, because that was one of my questions is, well, we're here for sentencing. Do you want me to just dismiss that? But apparently not. So Mr. Goddard.
Yes, sir.
It's alleged that you are, who are you looking at back there?
My wife, sir.
Do it again.
Anything, all I do is turn around. I'm sorry.
Do it again, and we're gonna have major problems, Mr.
Okay.
Eyes up on me.
Sir.
It's alleged that you're in contempt of court for violating court orders by having contact with your wife and attempting to influence her with her testimony. That would constitute a contempt of court. The prosecutor is considering whether to charge you with additional crimes. From the eyes up at me.
I'm looking.
On the contempt, I could give you 93 days in jail or $500 fine, $7,500 fine, or both.
Yes, sir.
Also, of course, that would impact what I might want to do on the sentence here that you're standing in front of me for. You have the right to have a hearing on that allegation where your contempt would need to be proven beyond a reasonable doubt, and the right to the assistance of your lawyer. I'm going to enter a not guilty plea for you. I don't want you to plead guilty to a contempt or anything because the prosecutor's thinking about new charges. So we'll enter that as a not guilty plea. And Mr. Parchi wants to schedule that then for a contempt hearing, sir.
I guess, Your Honor, yes. Yeah.
So let's schedule this for a contempt hearing February 2nd at 11 a.m. I don't want you looking anywhere to the side or behind. February 2nd at 11 a.m. Contempt hearing and continued sentencing. Let's get Mr. Goddard out of here.
Yes, Your Honor.
If I may, Your Honor.
Welcome to.
Yeah,
The people request no phone privileges while in jail except for religious counsel.
granted. Phone privileges revoked except to his lawyer. Submit an order to that effect.
Yes, Your Honor.
Mr. Parks, we also have people be twos that have been continued.
May approach, maybe approach, Your Honor.
Yes, indeed. All right, people be Ricardo Harris, file 25-93380FH. Counsel, you want to state your appearances, please?
Jeremiah Buffalo work on behalf of the people.
Dave Funk, P26715 on behalf of Mr. Harris. Can you see Mr. Harris on the video, Judge?
Indeed, I can.
Oh, okay, thank you then.
All right, and we're here for a docket call. What's our status in this matter, Mr. Funk?
I'll leave this up to Mr. Wirgo, who called me this morning and had some comments to make on our status.
Yes, Your Honor. Defense counsel very diligently has been on top of this case. We did believe we had a resolution going. As of this morning, there are some new facts that have come to light that may impair that resolution. We really need to get a handle on those before we could resolve this, Your Honor. This is, again, I want to make clear to the court, this is not a lack of work on behalf of anybody.
Okay. All right, any objection to continuing this then, Mr. Funk, to February 2nd at 10:30 a.m.?
I have no objection except February 2nd, I'm due for brain surgery in Petoskey.
Oh, okay. You available on March 2nd?
Yes, sir.
Okay. All right, let's do March 2nd at 10:30 for a docket call. And I'll allow Zoom appearances and anything further from the defense?
No, sir, other than drive carefully today. It's nasty up there.
Yes, indeed. Anything further from the people then?
Just my well wishes to Mr. Funk, Your Honor.
Okay, yes. Best wishes to you, Mr. Funk, and we'll see
Thank
you in March then.
Thank you, sir, very much. Have a good day.
You too.
Zachary McLennan for the people.
And good morning, Your Honor. James Gilbert here on behalf of Mr. Chapman, who's standing to my right.
All right, and we're here for docket call. What's our status here?
Your Honor, we do have a plea agreement. We've discussed it. I have discussed it with my client. We are asking if we could have the February date, and at that time, we'll tell you whether we're pleading or going to trial.
All right, let's continue with any objection, Mr. McLean?
No objection.
February 2nd at 10:20. We'll use that as a plea or a plea cutoff date. And anything further from the defense then?
No, Your Honor. Thank you very much.
People?
No, Your Honor.
Mr. Chapman, we'll see you then. Thank you. And that brings us, Mr. Gilbert, to people be Selena Valentine.
Yes, Your Honor. I know she's scheduled for 10. I haven't had contact with her. There is a
Maybe we should
concern.
pass the case till then, since there's show causes and I actually, since then, she had failed to report and I've issued bench warrants for her and both those as well. So I'm sort of expecting that she won't appear. Well, I guess we don't need to recall it unless she does appear.
Okay, all right. That's my,
But
that's my concern.
it's already in warrant status. So I mean, we could do another warrant for her failing to appear today, if you wish. And then we'll leave it without date and warrant status unless and until we get her in custody. If she does appear today, let me know and we can recall it and see where we're going on.
Excellent. Thank you.
Let's file 25-3358FH for docket call. We're scheduled for a trial in March, and there's been some discovery issues. Where are we at with all that, Mr. Roper?
So where we're at is that there's been a plea agreement reached. The agreement will require we're stipulating that the court remanded to the district court for entry of a plea to a misdemeanor with a sentence agreement down.
Mr. Wergo, is that correct?
Absolutely, Your Honor.
All right, so we'll remand that case to 89th District Court for plea taking, take it off the trial docket. And Jerry, if we can, we'll prepare a judgment and then, so then because you both have placed it on the record, I don't need you to submit a written step. We'll just do a judgment of remand from the court.
All right, thank you.
Perfect. Thank you, Your Honor.